For pronouncement of judgment, item 33.
Yes. We have held that the satisfaction that was required to be drawn by the government was duly drawn, and that was not disputed by the petitioners, and accordingly we hold that the no further proceeding is required to be, the PL is not required to be further considered, and accordingly it is closed.
Item 34.
In view of the above discussions and conclusions reached by us here in above, the writ appeal is held to be devoid of any merit, and consequently the same stands dismissed.
Adjournment request, if any, from item number 1 to 5. From item number 6 to 15.
My pleasure, Lordship. My lord, I beg to mention item number 11, my lord. I am seeking adjournment, my lord, be listed any day after 20th of this month. My lord.
You are, who is appealing for the other side?
I am the for the appellant, my lord.
Who is for the other side?
Other side is the government, my lord.
Have you informed them?
But I did not inform.
Why? Who is appealing for the government?
Government, GMDA and
Adjourn.
Yes. May please, Lordship. Regarding item 6, my lord, we want to withdraw this appeal, my lord, with the liberty to approve the learned single just for clarification, my lord.
This item number
6, my lord,
6.
Lordship.
What clarification you need now?
Against, my lord, some observation, we approve this honorable division bench, my lord.
It's one number 1. Service completely. Withdraw.
As per the office report, the service of notice upon the respondent number 1 has not been affected. However, learned counsel for the applicant has submitted that he does not want to press this IA as well as the connected writ appeal 7443 of 2024. However, seeks liberty to approach the learned single judge for clarification of the order. Dismissed with liberty as straightforward. IA number so and so, as well as the connected writ appeal dismissed as not pressed with liberty as straightforward.
My pleasure, Lordship. I beg to mention item 14, Lordship.
Yeah.
I beg adjournment for today, Lordship. Any date on next week.
Degree normal beginning with the diploma. But nothing interesting is there is no promotion that continues to be put to after we can.
Commencing from 18th, like we did that.
2011.
Yeah, please, your lordship, with the consent of the other side, I beg to mention item number 12. Lordship, may kindly fix the
Adjourn.
item number 12.
Adjourn.
My lord, with
Lordship.
consent of the
I'm for the appellant in.
with consent of the respondents, I beg to mention item number 10, my lord.
Adjourn.
Much obliged.
10 weeks. I'm not interested in doing this. This is the fourth time you are seeking adjournment.
Much obliged.
Adjournment request from item number 16 to 28.
May I please, your lordship? With the consent of the petitioner, I beg to mention item number 21, lordship. Matter be kindly adjourned for 2 weeks.
Adjourn.
Obliged.
May please, your lordship. May please, your lordship. My lord, with the consent of the other side, I beg to mention item 25, my lord.
Yeah.
My lord, if it is not inconvenient, can it come out for 2 weeks, my lord?
Adjourn.
Give
Please, lordship. With consent of the other side, beg to mention item number 26 and 27 of today's list.
Adjourn. Adjourn.
Much obliged.
From item number 29 to 32.
My lord, with the consent of the other side, my lord, I beg to mention item 23, my lord. The learned CCC 23, my lord. Learned CCC, Mr. H. Gupta is having some difficulty, my lord. Let the matter come after 1 week.
Another bench. Item number 23, another bench circle.
Not bad.
Much obliged.
Please, your lordship. Your lordship, with due consent of the other side, your lordship, I beg to mention item number 30 of the daily list, your lordship.
Item number
30.
30.
Yes, your lordship.
Adjourn.
Deeply obliged. Sir.
May I please, your lordship? Consent taken from the opposite party, lordship. I beg to mention item 29, lord,
Adjourn.
for adjournment,
Adjourn.
lord. For 2 weeks, lordship.
Adjourn.
Any other request?
May I please, Your Lordship? I beg to mention item number 18, that matter may be listed along with WA number 177 of 2023.
ये क्वेश्चन है ये वहां था कि प्रोविंशियलाइजेशन नहीं हुआ था जो कमी वो है जो फ्यूचर हम उनको टीचर क्या वो उन्होंने इन प्रोविजन
Which at the request of land council for the list along with on 6 weeks.
Daily list for orders item 1.
but उनको
Lordship, in this case, my lord, I have taken steps by register post as well as the Dusty, my lord, in respect to respondent number 7. But in respect of Dusty service, my lord, the respondent 7 refused to accept the same, my lord, in presence of his secretary and the members, my lord. To that effect, I have already filed in different affidavit, my lord.
Let me
Applicant. Treating. 4% is safe. Respondent number 7 has refused to accept the notice served upon him in the presence of the secretary and the members of the managing committee of the society. By saying that he has already received the said notice through registered court. The signatures of the secretary and the members of the managing committee are on the return, are there on the return notice. Stop. Taking into consideration the above facts and circumstances of the case and the affidavit filed on, and the additional affidavit filed on behalf of the applicant. We are of the view that the service of notice upon the respondent number 7 is complete. Stop. Let this, what is the matter about?
And this court division between 17 inch state.
This petition after this writ appeal. After 2 weeks, interim order, if any, to continue till next week.
Much of.
Item number 2.
Second time notice period. Service completely.
May I please your lordship, in this case, we may be allowed to take steps to Dusty. We have already taken steps to registered post twice, but it has not been served.
The notice issued to the sole respondent has not been served since long. And then the concept of the petitioner pays for and granted time to furnish the requisites for issuance of fresh notice upon the sole respondent. He may do so within a period of 1 week. On doing so, let notices be through registered dedicated. Let notice be issued to the respondent, the sole respondent, returnable 4 weeks thereafter. Dusty. Not registered daily, only the.
Item 3.
So,
3 and 4 have appeared.
May I please, your lordship, we take all the step, lordship, no ID card on serve, 29/3/2024, lordship.
They are with.
await return of notice for answered respondents for 4 more weeks.
Item 4.
May I please, the lordship? Lordship, as per office note dated 18/7/24.
3 and 4 have appeared.
4.
This for delay confirmation.
My lord,
How many days?
33 days.
Yes, what do you have to say? The notice, service of notice upon all the respondents is complete. Then this IA is filed on behalf of the applicant with the prayer to condone the delay of 33 days in filing the connected with appeal. When counsel appearing for the respondents have not previously opposed the application, having heard the learned concept of the parties and after going through the contents of the application, we deem it appropriate to condone the delay in filing the connected with appeal. Hence, IA number is allowed. The delay of 33 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and list it for admission after 3 weeks.
Item 5,
Please, fellows. In this matter, there's an office note of 6.
Respondent number 7,
Respondents,
8, and 9
yes.
has not been served.
There's one small thing that we filed an affidavit of proof of service. They've actually been served. We took the tracking reports from the desk pass section. We filed the affidavit, but it has not come on record. If this matter may come up the next week, it'll come on record. Next week's affidavit. May I request for the date, fellows, in the next week?
2011.
Grateful.
Item 7,
443 days. Complete.
May I please, your lordship, matter may be taken after some time, lordship.
Why?
My senior is court number 2, lordship. Our matter is going on that,
The delay confirmation.
lordship.
It was the reason for 433 days. 443 days.
They are claiming the pension. Going to rule that we are fully entitled to the pension or family. Yes. Who you should go, who qualify for that. Maybe was withdrawn.
Who is appealing for the other side?
I'm looking for the higher education department, my lord.
Do you have any opposition?
My lord, here the only ground is communication gap, my lord. And communication gap of, my lord.
Move for 3 days.
And in the
Review was filed, that has been withdrawn.
when review has been filed after a long time.
It has been dismissed on merit. Could
Uh-huh.
have been, if a review has been dismissed, could have been some problem.
Maybe at the insistence of London, the single judge, they might have withdrawn that with review. All are 78 years old now.
It has gone to Bangalore.
Yeah,
78 years old, he has gone to Bangalore.
now he's residing in Bangalore.
No, para it, but para it. From Kolkata to Guwahati, hardly 3 hours.
Suddenly has to go where his son is serving.
Family.
Bill and council, the matter comes upon for consideration of the application preferred on behalf of the applicant under section 5, the limitation is declared to condone the delay of 443 days. It is stated that against the impugn judgment, the appellant has preferred a review petition, however, the same was later on withdrawn. The review petition before the learned single judge, however, the same was later on withdrawn. It is further submitted that the appellant and the applicants are old aged persons. And on account of age related ailments, they have not prompt in filing the connected appeal against the impugn judge. Is also stated that it is for appellant number 1 went to Bangalore, where his son is serving for some urgent family affair. And he came back only in April 2024 and then contacted his counsel. Stop. It is therefore prayed that the delay in filing the connected appeal may kindly be condoned. When it comes to any further exponents have opposed the application and as argued that the delay in filing the connected appeal is not satisfactorily explained and therefore the same cannot be condoned. Having heard the learned counsel of the parties and after taking into consideration the amendment made in the para number 8 as well as the advanced age of the applicants, we deem it appropriate to allow this application. Hence, the IA number so and so is allowed. Delay in filing the 443 days. The delay in filing the connected appeal, the delay of 443 days in filing the connected appeal is condoned. Register directed to register the connected appeal and list it before this court after 4 weeks for it.
It is subject to deposit of some cost may be imposed because subject to deposit of some cost because
you want cost to be imposed upon you?
no, my lord, no.
No, it's okay then. If you want, then we'll import.
That's all I thought.
Item 8.
May please, Lord, sir. No, I for consideration of degree.
इसमें खाली एक चीज है जो एग्जामिन का सिंगल जज के बदल में एक तो रिटेपिंग
Page 58.
मतलब अपने को कि इनका जो रेगुलराइजेशन है वहाँ पे बदलाव नहीं है तो पहले एक रूल पता भी काम करेंगे तो पहले 3 साल को छोड़ दें तो वो 3 साल को इनको 20 बट एक मतलब के केस में वो जो वो इंटरफेस करेगी यहाँ पे without detecting this any other position then in terms of the pension rules, they will 67. It comes within that. considering the fact. But the actually about me.
Yes, ma'am.
And it is delayed for 5 years, 7 months, my lord.
The poor labor, not aware of the consequences.
No, my lord, I want to say, my lord, the earlier petitioner come to court and put his signature in affidavit, my lord.
Yeah.
An earlier petitioner, my lord, petitioner come to court and put his signature in the affidavit. Thereafter, he did not put his due diligence to contact with the advocate, my lord. This is the fault of the petitioner. So, and I also want to say that to suppress the
You are seriously opposing or simply for the sake of opposing, you are opposing? Tell us. You are seriously opposing this
Yes, your lord.
application or for the sake of,
Yes, your lord.
then file an affidavit, we'll consider it.
Yes, yes.
Counter affidavit, if you want to file counter,
Yes, sir.
and we'll consider. You're appearing for,
Respondent number 1, 5, and 6, your lord.
and another respondents? All the notices have been served? This IA comes upon for consideration of this IA is filed on behalf of the application. They pray to condemn the delay of 1633 days in filing the connected appeal. Full stop. Then it counsel appearing for the respondent number
1, 5, and 6, your lord.
1, 5, and 6 place some time to file. Counter to the IA time period for is granted list on when?
2 weeks, your lord.
3 weeks, just after 3 weeks.
Alright, Lord.
Deeply obliged.
Item 9.
What's going on?
But the I is for consideration of delay, there is delay of 137 days.
Notice. AB plus P, registered AB and the.
But we'll take justice test, can it be returnable in a shorter period, in 3 weeks?
3 weeks.
We'll take justice.
Registered AB and Dusty both.
Logic. How
Returnable 3 weeks, yes.
For admission, item 13.
The employee respondent, completed response. वो पहले का जो सब लिखा है वो कंफ्यूजिंग है इनका जो नहीं इनका करके नहीं है तो प्रोजेक्शन करने किया है यही कॉन्ट्रैक्टर अभी कंफ्यूजन यहाँ भी इंक्रीज अपने यहाँ इंक्रीज होता पड़ा the writ petitioner is the respondent number. Termination of the contract. Condition. Settlement. Order me. That will be taken care by the public employee. Like that, ONGC need contract. Will retain the no, that is not no protection. In your basement, the Indian Oil Corporation. It's not that's what the categorical finding is. Yes. Payment. They does not have any more with community when they get paid. In absence of one, they develop a put upon the other side. I think I specifically look at things of particular manner of in terms of the condition. मैं बोल के बोलूँ कि जो आपके टर्मिनेट वो अपना एक मिनट के लिए भी रखते हैं वो नहीं रखते
Yes.
My pleasure, Lordship. Lord, in this case, Bongaigaon Refinery protected a notice inviting tender to select a person to manage their canteen at Guwahati. The petitioner, read petitioner submitted his tender and his tender was accepted and he was awarded with the contract. There is no problem left. Then he filed two writ applications. First one is that according to him, the the workers who were working at the under the before the previous contractor, they are not vacating the canteen, and as a result, he could not operate these things, and he sought a direction from this court to vacate this contract. And secondly, the BRPL authority has terminated their contract, and in between that, we filed an application to get ourselves implemented. Accordingly, we were implemented as respondent number 4 to 25. Now, both these writ application was hard, and according to the learned single judge was of the view that we don't have any right. We don't have any right, and the petitioner can enforce their contract by virtue of the clause 2.1. And accordingly, the order was passed in his favor. Now, we approached before this honorable court by filing a writ appeal. Our contention before your lordship is that there were certain conciliatory settlement. All these terms of this conciliatory settlements were incorporated in the special contract.
Oh, you just show us that clause where this terms or terms are there. You show us the clause of the contract between the refinery and the contractor. That he is bound to engage those workers who are earlier working with the contractor.
Yes.
Where is that clause?
Now, your lordship come to page 84. Mm.
'84.
Oh, yes. Yes.
Yes.
Mm. There are some clauses. First, your lordship in there, just page 83. Clause 7.
83.
Clause 7.
What is this document by the way?
There is a conciliatory settlement
Between
between the Bongaigaon refinery and the union and the contractor also, contractors association.
contractor.
Contractor association.
This contractor, petitioner contractor.
No, no petitioner contractor. They are represented by their association.
What is that?
At page 80.
That is 0.
80. Memorandum of settlement under section 12(3) of ID Act arrived at between the contract workers represented by BGR United Workers Coordination Committee and the Bongaigaon Refinery Contractors Association over 39 points of charter of demand before the Assistant Labor Commissioner.
This contractor is the member of that association?
That I cannot say, but that was a conciliatory settlement in terms of this section 12.
The contractor association. Members of the association have entered into.
Whether he is a members of association, that is not material. So far, the section 18 of the Industrial Dispute Act is concerned. When there is a conciliatory settlement, it will bind to the every worker, every person.
Every person means every person who is not this party to the contract.
Yes.
Or settlement.
Yes, yes.
How can you?
Sorry, Miller. Can be taken at 2 Miller. Section 18 of the Industrial Dispute Act. I will.
Certainly.
I'm to full bit. Anyway, for the timing.
Yeah.
For the timing, let us keep it up. I will place it before your lordship. So section 18 of the Industrial Dispute Act.
That is there, section 18, yes. Give them this industrial dispute copy of the industrial dispute.
Person to whom settlement and awards are binding. A settlement arrived at between the agreement between the employer and the workman, otherwise than in course of conciliation settlement. Conciliatory settlement shall be binding on the parties on the agreement. What be that is it may, all these clauses were incorporated in the special contract. For the timing, my lord, we can. Mhm.
That is there. This admitted position that this petitioner contractor was not the member of this contractors.
Anyway, let us consider that the petitioner contractor is not the member of the association, and as such, though I am not agreeable, as such, it is not binding on them. Let us consider this thing.
It is not a contractors association, it is a contractual laborers association.
Anyway, whatever may be.
Contractors association.
But all these clauses
No.
have been incorporated.
Bangalore Refinery Contractors Association. They page number 80.
No, my lord, but not related to Guwahati.
Workers and BGR, United Workers Coordination Committee and Bogoigaon Refinery Contractors Association.
My lord, that is the refinery of the BGR refinery, my lord. That is a contractors association of which we are not signatory to the conciliatory settlement.
That's what we are asking.
No, Lord, whatever may be there.
Is there any clause in the contract entered into between the refinery and the contractor that this settlement is binding on them?
Anyway, for the timing, let us keep it this point. All these clauses which are incorporated in this settlement have been incorporated in the special condition of contract.
Where is that?
So that will solve our problem. We can avoid this point also. Your lordship will come to page 158. For the timing, let me escape it off without going to the goal of controversy. Aforesaid clauses were incorporated in the special condition 158. Clause 14.5 onwards. Clause 3, clause 4, clause 5, clause 6. All these things are incorporated.
So, this 14.5, where it is there that this contractor is bound by the settlement arrived at between so and so on so and so date. Where is that? Or any other settlements arrived between so and so, where is that?
No. Let me skip off this point. So far, the settlement is concerned.
Every point you are skipping, then.
No. Your lordship may consider clause 5.
Why?
The contract worker will be paid the statutory allowances, daily wages allowances, it was a bonus towards gratuity and retrenchment. So every contractor has to pay 4.8% towards the gratuity and retrenchment to their workers.
That can't lead to this, that the gratuity and retention, therefore they are, he's bound to engage the employee, the workers which were earlier engaged by the contractor. That can't, we can't stretch up to this, sir.
Retrenchment compensation, gratuity compensation, ESI bonus.
Maybe there is a mention about that.
Yes.
He can't stress it or stretch it up to this limit, that this amount that he'll engage the workers earlier with the working with the other contractor. That's very difficult. Is there any condition in the NIT of this effect? In the NIT, was there any condition of this effect?
NIT is not there, but the special condition of contract. It is very special.
Yeah.
The page 158, clause 14.5, the part of the NIT.
Yes.
NIT.
Yes,
This is a-
14.5.
14.5.
Any specific clause in this NIT that the contractor shall be bound by so and so agreement arrived at between so and so.
No, there is no such clause, but the agreement, which were arrived at has been incorporated in the special contract, as my learned friend has indicated at page 158.
14.5.
14.5.
The Industrial Disputes Act.
All this clause.
Otherwise also, even if they are not party to the conciliation, it would be binding.
Yes.
On them.
Section 18.
Section 18 of the Industrial Disputes.
Section 18 is read section 18.
Yes.
Read section 18.
Section 18.
We should be here. Hello.
Section 18.
There is an arbitration clause also here. All right.
Was now. Section 18 binds only to the parties, sir, not everybody.
Under the law. So logically kindly come to, I think, subsection 3.
Yeah.
It shall be binding on B. Where a party referred to in clause A or clause B is composed of workmen, all persons were employed in the establishment or part of the established entity which dispute relates on the date of the dispute, and all persons who subsequently became employed in the establishment or
Employee.
Workmen.
That is very difficult to stretch up to this extent.
But the only thing is special condition also.
Automatically.
But special conditions of contract is a part of the contract, general conditions of contract.
These special conditions also can't be stretched up to this level until and unless there is some element in the NIT or in the contract.
But from our perspective, our only problem is, my lord, it will lead to a huge industrial unrest. Because these people are being.
Then you should have mentioned it in the contract itself or in the NIT, sir.
If your lordship will kindly permit me to place one aspect, if your lordship will kindly come to page 252. I'm sorry, 152. Page 152, the contract start that I've already placed 158.
Yeah.
Then will not really kindly come to. Lord, there are some documents which are not annexed to the requisition. Sorry, in the written appeal. Well, there are two petitions were disposed of by the learned single judge. Now, those were part of our additional affidavit which were filed before the single judge. But can I take on fair, Lord? All this background, let me say, I'll bring on record those, my lord, by your pen, photocopies. I think now those documents are not visual now.
Yeah.
Yes.
From. Yeah. 13. When is it, my lord? It's on that.
Public.
Item number 15.
Only the person does being secondary. Before to the English. Who continue to promote the party bill 2022 में उनका पहले जो एसोसिएशन not the employment because they are wrong. I think they are past the age of employment. 55 people. 55 maximum.
Yes, sir.
This writ appeal has been filed challenging the order and judgment and order passed.
Yeah, that is there.
Yes, your lord.
What is in the merit?
Lordships.
What is in the merit?
Yes, learned single judge's opinion or view was that our writ petition was dismissed only 2 or 3 points as a ground that.
Round of delay.
Yes, but this is not.
And second, that you have not made party to the person who appointed way back in 2000 something.
Regarding the 84 numbers of teachers who do not belong to the SC community.
Right.
That list has been the similar order that we have prayed for in WPC 1785-2012. The order passed in 10/5/2022. The WPT, presently the response number 4, has been asked by this honorable court or director to provide that list of 84 numbers of teachers, because we have only the 10 numbers of candidates from our list, SC beneficiary list, that we could have availed from the department that they were appointed. Rest 84 we have prayed, and this honorable court, as per the similar order, given the direction to the respondent number 2, court to give us the list. That was the similar order that we have prayed. Although we have prayed, other prayers are there, but this relief was granted. That similar order.
Similar order.
This was by an association.
Page 56 to 59. Annexure 11.
Belonging to something. First to do well, nothing in the country.
What is that order passed by the learned single judge?
In that we have challenged.
2022, what is this order?
Order passed is page 58, para 7, your lordship. In the circumstances, we have no other option because we could not provide the list of non-SC candidate 84 numbers. So direction was given, no other option but to close the petition requiring the respondents in the WPT and BC department to provide the petitioners association with a list of persons who were the beneficiaries of the amount which was unmarked for the persons belonging to the SC category. Once the list is made available, the petitioners may be examined if for themselves, and if they find that any such person who do not belong to the SC category were also the beneficiaries, appropriate representation may be made to the so-and-so department, Govt of Assam, for paying the proportionate amount to any stipendiary teacher belonging to the SC category of the Karimganj district who otherwise would have been the beneficiaries of the said amount. Yes, Your Lordship. We were not the teachers, but since 1993, first order passed by this honorable court, we are not teachers. Yes, Your Lordship, but we were the 84 numbers deprived beneficiaries supposed to be because this has happened due to deprivation took place. Your Lordship may peruse. Yeah, yes, 1991, 92. No, Lordship. We have approached, if Your Lordship may peruse, then since 1993, we are before this honorable court. And at least this direction. But Your Lordship, one thing I would pray that this, whatever orders earlier passed by this honorable court, on this honorable court, were in our favor, and due to administrative negligence or whatever it is, because these were not acted upon, Your Lord, at that time. The 2 or 3 vital documents were also there. They were not looked into. There is an order dated 28/2011 and another 7/2011. If Your Lordship kindly peruses one ground that I have taken, where specifically the order dated, detailed report dated 28/2011, where the government has Lordship. No, I have a ground number 4, Lordship, that I have taken at page 24. For the honorable single judge who are passing the improved judgment and order dated so and so ignored the fact that the deputy inspector of schools Karimganj district, while submitting detailed report dated 28/2011, that is annexure 8, page 51, where they have admitted that it is a fact that the main grievance regarding appointment of 421 numbers of stipendiary teachers appointed on 16/11/1992 as per selection of the subdivisional level advisory board, Karimganj, and all the 421 numbers of land posts were originally created by gov letter dated so and allotted by the Director of Elementary Education Department, Assam, by letter dated so and so. Out of 421 numbers of post secondary teachers, 94 of posts were reserved for SC candidate, where only 10 candidates from the SC community were appointed, and 84 numbers of posts were filled up by non-SC candidates, for which the above figure of SC candidates were deprived, and the petitioners of the WPC 2407/2001 are belong to that group, your lordship. So we being we appellants being the members of that association, 2001 also prayed for. Since 1993, we have been raised the issues regarding illegalities committed while appointing the 84 numbers of teachers, your lordship. At this stage, maybe 10 years left due to delay, but it is not a fact that we are for the first time before this honorable court. At this, no, just I have, if your lordship, my submission is that the basic ground that has been stated while dismissing the writ petition is that the delay ground. Because as per your learned single judge, we have approached this honorable court, who should have been in the year 2012 along with others. But in the year 2022, we have appeared along with the praying for similar relief. But my submission is that it is not the first time before, because our association has been fighting since 1993. And some documents are there vital that I have taken as a ground, 7/2001 and specifically 20/2011, where that has been admitted by the department. And another thing is that although orders have been passed, we have been fighting since 1993 due to administrative negligence or whatever that has been stated, these orders are not acted upon. But at this stage, as the honorable single judge given a direction to provide the list, at least we may be given an opportunity to go through the list, 84 numbers of teachers. That has not been, that is not provided, your lordship. Because writ petition has been. Other prayers are also, if your lordship kindly peruses, other prayers are also there in this. Although I don't know how much page 28, your lordship, relief sought for in the appeal. That since 1993 we have been fighting the same reliefs, your lordship. Just up to your lordship. Because at that time, as per order passed in the writ petition 2401/2001, this honorable court was pleased to give a direction not to fill up the posts. Annexure 6, your lordship. In the meanwhile, 84 numbers of posts meant for scheduled caste candidates in Karimganj subdivision, as indicated by letter dated 7/2001 of the Govt of Assam Education Elementary Department, shall not be filled up by. And that order was made absolute while disposing of the writ petition, your lordship. Annexure 6, page 43, Your Lordship. Substituted by subsequent respondent number 4, social justice and empowerment.
Welfare of plain tribes and equal classes. Plain tribes. Social welfare, social justice and empowerment.
Item 16.
May it please, your Lord. Lordship, we have challenged the impugn order of the Honorable Single Judge in this case, whereby it was held that the cessation of service of the petitioner was not valid, your Lordship. If I may place the brief facts of the case, your Lordship, the petitioner has joined the service of the bank in the year 1985. 1985, your Lordship. Thereafter, your Lordship, he has attended his last office on 28/12/2001. 24/11/1985. Lordship. And his 28/12/2001, your Lordship. One, your Lordship. Thereafter, he was on unauthorized absence, and on 22/2/2016, he expired, your Lordship.
2016.
22/2/2016. From 2001 to 2016, he was not in service, your Lordship. And in the year 2019, your Lordship, the petitioner's wife has approached the bank with a representation claiming the retirement benefits, your Lordship. Your Lordship, 60 years. Lordship. On the date of his death, he was aged around, Your Lordship, 36 years. Yes. No,
16 and more, but if it's permanent under the condition. No, you're not there. It cannot be. Your Lordship, this case is very simple, Your Lordship. What happened in this case? The petitioner, that is the present respondent's husband, he rendered continuous service from 1985 to 2002. And nowhere in the petition, the petitioner has tried to hide the fact that from 2002 to 2016, he has been absent from service. The petitioner very clearly, from the very beginning, has mentioned it clearly that he has rendered service from 1985 to 2002. That is more than 17 years, Your Lordship. And according to the SGI rules, as per the central government guidance, that at least if someone working for 15 years is entitled to voluntary retirement scheme. And if Your Lordship, after a long period of time, they have been repeatedly told to produce the documents before the court. And after a long, even after a strict reminder by the court, they ultimately produced the documents. And in the documents, it came that whatever notice were given to him, after that he was again in service. And in all the notices, it was stated by them, not by me, Your Lordship, that if you don't join service within this period, you will be deemed to be voluntarily retired. Nowhere they have stated that you will be dismissed. If I have not rendered service from 1985 to 2002, then why they have mentioned the term voluntary, you will be deemed to be voluntarily retired from service? Because they know it, voluntary retirement scheme. Yes, Your Lordship. From 1985 to 2002, Your Lordship. Yes. I'm not claiming anything beyond that. I'm entitled because as per their rules, someone if renders 15 years of service, then he is naturally entitled to it. Your Lordship, I can produce.
Lordship. 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 As per the bank extent rule, Your Lordship, 4 notices has to be given. Your Lordship, in our affidavit in opposition, Your Lordship, we have annexed all the notices. Lordship.
Interesting, Your Lordship, if you kindly see the dates of the notices, one from another is.
Also, I have a copy of the extract. Rule.
Thank you.
Your Lordship, State Bank of India leave sick specifically an ordinary leave. Your Lordship, it is an if your Lordship date is given, then I'll produce the entire set of rules, Your Lordship.
Your Lordship, and that is the same thing which they have
Probation-
prolonged done in before a single bench.
Your Lordship, SBI service rules, Your Lordship. Lordship. SBI service chapter 2, probation, confirmation, extension. Your Lordship, the extract of the rules I have, Your Lordship.
Your Lordship, I can also help your Lordship if wish. This is a very recent judgment 2020 where the rules of SBI have been discussed, your Lordship. Have I go to- How you answer? Judgment of the level. It will be there. It will be there.
Lordship. Yes, yes, Lordship. Lordship.
Your Lordship, the rules have been, Your Lordship, I have given 2 copies of the judgment of the Honorable Supreme Court where the rules of the SBI has been very properly discussed, Your Lordship. And another is SBI is that one, Your Lordship. Because they have not been producing since 2020, Your Lordship. Unnecessarily delaying the matter. Yes, Your Lordship. And the provisions. Your Lordship, the clauses of the SBI rules, according to which I'm entitled to at least voluntary retirement schemes benefit that have been discussed in the judgments, Your Lordship. The rules have been discussed, Your Lordship, in the judgment. I have marked the important provisions, Your Lordship.
I may be allowed, Your Lordship, to place it on record. Applies, Lordship.
Item 17.
Fragmented.
Lordship, the Gazette judgment 189, my lord. Yes, my lord. Now, my lord, here the charge sheet was issued, my lord. Then, my lord, punishment of dismissal from the service of past preferred an appeal, my lord. Now, Lordship will kindly look into the observation of the first departmental appellate authority, it page 155, my lord, regarding the aberrations in conducting the inquiry proceedings, my lord. It page 50, start from page 55, my lord. What should Lordship will find? 155, Lordship. It's clearly discernible that, my lord, there is aberration of rules, some service and discipline rules, as well as the principle of natural justice. My lord will find 155 from the order sheet records and the findings of inquiry of the DP. The following facts comes to the light. At the outset, it is stated the appellate authority arrested and forwarded to the judicial custody on 12/4/2014. In connection with the Panvel police case number so and so, but was placed under suspension on 23/2015, and that too upon receipt of the report from OC Panbajar PS dated 23/2015. The reason as to why the OC submitted a report to the authority after a lapse of more than 1 year is a matter of question. The appellant authority, after receipt of the show cause notice dated 13/4/2015, submitted his written statement in defense on 27/4/2015. The disciplinary authority was not satisfied with the written statement, initiated a departmental proceeding number so and so, and Simoti so and so. SP Jalukbari was appointed the inquiry officer to inquiry into the departmental proceeding by order dated so and directed her to submit the findings of inquiry within 3 months. RI Police Reserve was nominated as the presenting officer. The suspension order was revoked on so and so date. Pending inquiry of DP, the inquiry officer submitted her finding of the inquiry. Next, my lord, EO fixed the date of recording of the statement of PWDs on 29/8/2015, namely so and so, 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 so and so. My lord, these are the witnesses. Some of the witnesses are listed witness. Some of the witnesses are not listed witness, my lord. It is mandatory, my lord, list of witness to be found. If they want to, my lord, examine some of the witness, are not permissible to examine witness, which is not a listed witness in the show was not issued, my lord. That has been finding of the first departmental appellate. Observation, my lord, observations. Then, my lord, will find the findings. It is from the record, it is. It's. Yes. As per record, my lord. Last paragraph. As per record, you recorded the statement of so and so, so and so, so and so, as well as so and so. It is seen from the proceeding. Now, my lord, will find thereafter, my lord, as per record on the same 155. You recorded that the statement of so and so, as well as the charge officer on 21/9/2015. It is seen from the proceeding that EO did not put his signature date even after recording the statement of the PWC namely Sri Dilip Bharali and the SIUB Sri Abu Bakr Siddiqui. Thereby cross-examination was found on the body of Abu Bakr Siddiqui is doubtful. EO put his signature without date on the body of Vichitra Borgohain and charge officer Sikandar Ali Ahmed. In this context, it is stated in the law that now well settled that it is the duty of the inquiry officer to inform the delinquent officer that he has a right to assisted by another government servant of his choice. The government servant declined to avail of the if the government servant declined to avail the opportunity, the inquiry would proceed. But if the delinquent officer is not informed of his right, and if it is found that the delinquent officer suffered a result of that, it will vitiate the inquiry. The law is further well settled that at any time, the inquiry officer at least should inquire from the delinquent officer whether he would like to be engaged any of one from the department to defend him, and when the delinquent is in a government service belongs to a lower sector of the service, he would further be informed that he is entitled under the relevant law to seek assistance of the another government servant belonging to the department to represent him. There is no such information available as per the order sheet that the inquiry officer shared about the information under the relevant provision of the rule with the delinquent officer as per the circular dated so and so issued by the Assam Police Headquarters by memo number so and so. You has unauthorizedly recorded, my lord, will find. Statement of Dipunjoy Kakoti appears as is no more nor cited in the list of witness in the show cause notice. So Lordship. Well, that is also from the record, my lord. That is also, but there cannot be two sets of record, my lord. No, I am not saying that, my lord. I am not saying. What I said, my lord, are whatever the learned single judges found, that there is no aberration so far the procedural aspect is concerned, my lord. That is believed from the, my lord, the department, because he is the authority who has also gone through the record, my lord. Yes. So that is the problem here, my lord. Yes. My lord, here lordship will kindly see. Here many cases, my lord, the parliament authorities found that a type statement of the some of the witness was furnished. That and my lord, the date put by the my lord, the prosecution it is one date put by the my lord, the delinquent officer and the presenting officer is different. After 1 month, the date of the witness, my lord, the signature of the presenting officer and the delinquent officer was put on the statement, my lord. So therefore, it implies, it is noted in that, my lord, on the way, he was not given the possible opportunity of cross-examine, my lord, because it is on the same date. And my lord, as per sub rule 9, my lord, when an order of punishment is passed, If he is a disciplinary authority, he has to file findings on his charges. There is no such finding in his charges. My lord, under rule 9(2), my lord. If your lordship, my lord, and the discipline authority shall, if it not the inquiry authority, consider the record of inquiry and record his finding on his charge. Now, if your lordship look into the observations, my lord. Well, appellate authority, first appellate authority, lordship. My lord, at page 159. My lord, on going to the entire record of the DP file. My lord, the EO did not note down the date even in a single proceeding of PW recorded among the 9 proceedings. Beside, EO did not put his signature on the date on 3 proceedings, which were further raise a question of validity and genuinity of the proceeding as recorded in the presence of the appellant. EO did not maintain the order sheet regularly by noting down the step taken and reason on each of the date of correspondence. It appears from the record of the note sheet that DP file number EO recorded the statement of PWs and the appellant on 21/9/2015. It is worthwhile to state that EO has not followed the settled procedure on the rule as prescribed established charge, but in instant proceeding, EO has recorded a statement appellant on the very first day of conducting DP. The EO should have completed the record of the statement of those POs shown listed in the show cause notice, thereby process of conducting the DP at the very initial stage suffered from a serious setback. It is, my lord. Thus, the act of the EU carries a bad test of the entire inquiry proceeding. The record revealed that statement of Inspector so-and-so was recorded on 21/2017, but then was information regarding recording of statement of pending PWs in between 29/2015 to 10/1/2017. Thus, the matter of recording the statement of few PWs on 28/10/2016 or any other date as reflected in the proceeding of the PWs and the absence of the date signature of the EO in these proceedings, my lord, not only created reasonable doubt, but also raised a question about the appearance of the presenting officer and the appellant at the time of recording the proceeding. Now, my lord, there is no information in the order sheet that inquiry officer had inquired from the appellant, whether he then, my lord, the defense assistant, now my lord will pay one para E. Some more irregularities found in the DP file. Firstly, PW put his signature and the date of the proceeding on 29/2016, but the appellant and the presenting officer put their signature almost 1 month later on 26/2017. Secondly, type statement of PW was received as per order sheet on 21/9/2015, but the appellant and presenting officer put their signature and the date more than 1 year, that is on 28/10/2016. So, my lord, some of the POs, my lord, submitted a type statement that was recorded. And my lord, when they presented, they were allowed, they are asked to put their signature. So, what is the cross-examination, my lord, on that part? Now, my lord will find presenting, but both the lapses clearly shows that neither the appellant nor the presenting officer was present on the due date, but signature was taken as a part of semblance of inquiry. My lord, page 160, my lord. This act was done by the EO using her administrative power or not as an inquiry officer, ignoring the fact that she has to act as a judge in the quasi-judicial proceeding. The most serious lapse of the inquiry report is that inquiry officer recorded a statement of prosecution witnesses, Pranavjyoti Goswami, a PS DCP traffic, AS IPWA. In his statement, Pranavjyoti Goswami said that RC book number so-and-so, which is the bone of contention, my lord, were issued to then Inspector of Traffic Police, Traffic so-and-so Pandu Division from his office of the Superintendent of Police City Guwahati Naidan and received by UBC so-and-so, my lord, appellant. Whereas the inquiry report AO stated that secondarily received the RC book on behalf of the Inspector Shatradhar Kakoti. Similarly, Inspector Dilip Bharali, then officer in charge of the Panbazar PS in statement, recording in Assam status so-and-so, issued the RC book to the Inspector of so and so and hand over the RC book number so and so to the so and so serving under Jalukbari police station. In the inquiry report, the inquiry officer recorded the statement of prosecution witness, Sri Dilip Bhorali, the then OC of Panbajar PS, IPWE. In his statement, he said that SP Traffic Guwahati Sri Pranabjyoti Goswami appears DCP Traffic Guwahati issued 2 fine book number so and so to Sikandar Ali. My lord, there is a, in my humble submission, and there is a, my lord, the procedural aberration as well as, my lord, the violation of principle of natural justice. Because it is the highest punishment has been imposed by the dismissal of the, had it been other, that's a different issue. That's to state observation of the procedural rules, as well as, my lord, the principle of natural justice. Because he is a very low rank of the, my lord, and lordship will find that he is not only the person, because it is the duty of the higher officer. They are involved, they are, my lord, their duty to collect the fine, their duty to keep custody of the books, my lord. He has made a scapegoat, my lord. If and the, my lord, statement of witness, my lord, if your lordship kindly, my lord, you will find that, my lord, the probe is not totally proved, my lord, because there is a variance in the statement of the witnesses presented by the prosecution officer, my lord. Only that he belongs to a low rank officer, my lord, otherwise left out, my lord. 161 lordship, last paragraph, my lord, you will find. The second show will The second so-called notice, the appellant stated that he being a constable attached to a PS, dealing it is under Rule 38 of the AP Manual Part 5. Rule is very clear that a constable cannot be a custodian of a government money. The inquiry officer recorded a statement of POs in his absence in violation of settled procedural rule. He was informed about the valuable light for which he could not avail the opportunity service of the government's servant as assistant in a inquiry and stood undefended in the instant inquiry. The inquiry officer did everything right from the recording of the statement of PW in support of the charge and exhibited the documents, collected every material against him. Question documents have not been produced and probed in the DP in violation of principle of natural justice. There are many documents, my lord, I'll show, which was relied upon by the inquiry officer during the inquiry proceeding, which was not a listed document, my lord. For example, my lord, the case diary. Case diary is a privileged document. It's not available to me. It was not, I'm not allowed to go through the case diary. But he has relied the case diary, my lord. While coming to the findings of the inquiry officer, what statement was recorded in the case diary? How the case diary was people on the basis of what statement? Nothing was, my lord, made available to me, my lord. Huh? And my lord, it is a rule line has to be strictly complied with, my lord. My lord, because if you examine some witnesses, they should be listed in the show cause notice. Here, my lord, there is a finding that some of the witnesses have been listed. These are not listed witnesses, my lord. Secondly, my lord, some type statement was given to the furnished before the inquiry officer. The inquiry officer accepted that, my lord. And my lord, then we were called, we put the signature after 1 month or after 6 months, like what is the finding, my lord. So therefore, my lord, statement was, it is not that, my lord, that officer, prosecution author presented before the inquiry officer on that day. His statement was recorded in the presence of the inquiry officer. And my lord, on that day, I was allowed to cross-examine him. Some of the, my lord, the deputy inspector, DSP, he has furnished a written type statement. So this is the case. Here, the inquiry officer received that. He called me after 1 month and presenting officer. On that day, he was allowed to ask us to post our signature. What is the cross-examination, my lord, on that? My
11 minutes.
My lord, I. My lord, my lord, so far the punishment is concerned, my lord. Only so far imposition of punishment is concerned, my lord. Why that, my lord, my lord, no charge of the charge of misappropriation has not been proved, my lord. Charge of misappropriation of money is not there, my lord. My lord, this is collected by inspectors, my lord, not by my lord. That is like.
Item 19.
May I please, Lord, sir? In this case, my lord, there was a direction to file an affidavit. My lord, may I pray? Region, my lord, there was no such condition while, my lord, issuing the settlement order. There is no such condition or my lord restriction of my lord transferring the land for 15 years in the order of settlement and the cabinet decision. That was the instruction. Yes. No, my lord, so far policy is concerned, it is only for the individual, not for the organization. Whatever may be my learned friend, my lord, received the instruction. May I pray, my lord, she is going to file the detailed affidavit or on behalf of the government because he is representing the revenue department, my lord, 1 to 4. My lord.
The instructions, but I'm still awaiting the annexures because of the recent holidays. The annexures, because of the ongoing holidays. It's a the documents, the cabinet decision, etc. All those documents I'm awaiting.
Page 49.
Within 10 days time may kindly be granted to my lord file the affidavit, my lord.
Even 49. 49. Government order transfer.
One affidavit has been filed.
Affidavit on behalf.
After 2 weeks, when we grant. 2 weeks time.
Two weeks.
Okay.
Item 20.
My lord. This is a lead appeal, my lord, against the order. That is case number 14, my lord. Case number 14, my lord. The relevant person is case number 20, my lord. Para 17, may I read, my lord? Para 17. In view of the discussion held above, the court considered appropriate to grant similar review as has been done by the coordinate bench in WPC number 4517/2000 as such in view of interference by the court of the inquiry report dated 16/9/19 as well as the order of dismissal dated 30/10/2016 passed by the disciplinary authority. The petitioner is directed to reinstate as a constable in CISF with immediate effect and service benefit applicable to the petitioner will be released by the authorities as per the provision of law. The petitioner will be given notional benefit of his service and seniority be also protected. In view of the injustice found to have been caused to the petitioner, this court sustains the payment of lump sum 2 lakhs as a back wages which would be considered as the just and proper compensation for the injury suffered. My lord, that 4517, my lord, that is that order of 4517, my lord, on the basis of which the Honorable Single Judge passed this order, my lord. My lord, 4517, my lord, kindly see paragraph 17, last part, my lord. 17, yes, my lord. The information inquiry proceeding is reason for the above intervention. Now the question is whether this call for a fresh proceeding. By now, 22 years have gone by and the de novo inquiry may not be feasible now. Now, since the witness are unlikely to be available, the delinquent as can be appreciated has suffered a lot in his pursuit of the justice. Moreover, the incident, the passage of time has surely lost its relevance. Hence, I feel that ordering of de novo inquiry may not be justified at a point of time. Accordingly, having held that disciplinary proceeding was vitiated, the respondent directed to reinstate the petitioner. He will be entitled to notional continuation of the service and his seniority should be protected as a fruit of his successful legal battle which commenced in 1997 in Allahabad High Court has hopeful ended today in this court. The long suffering out of the job litigant must also be nominally compensated in the sum of the lump sum back wages of 2 lakhs, my lord. But in this case, in our case, my lord, kindly see case number 23, my lord. Case number 23, paragraph 2, my lord. Against the said dismissal order, the petitioner initially approached the High Court of Allahabad by filing a writ petition number so-and-so 19-9 by the order dated 15-9-2006. The Allahabad High Court dismissed the writ petition on the ground of lack of territorial jurisdiction. Thereafter, the petitioner approached this court by filing the instant writ petition. However, during the pendency of the writ petition, he was convicted by the criminal court and put behind the bar. As a consequence thereof, he could not instruct his counsel and the instant writ petition came to be dismissed due to the non-prosecution by the order dated 28-11-2013 passed by this court. After his yes, my lord. My lord, here, my lord, in that case, they are continuously in the legal battle, my lord, but he was behind the bar, rightly or wrongly, my lord, from 2013 to 2021, he was behind the bar, my lord. Then, my lord, seniority and the back wages, my lord, my humble submission, he is not entitled for the back wages, my lord. There is no fault on the employer or other part, my lord. Because, my lord, that is his own fault, my lord. Back wages for back wages and seniority, my lord. That has been protected by the single judge, my lord.
Yes, 2013.
13, my lord. And on the day it was dismissed for non-prosecution was the day when the writ petitioner was put behind bars in the other case, my lord, which was pending in his hometown. Now, the day he got acquitted, he was finally acquitted. He came back, he found out that it was dismissed for non-prosecution. He moved an application restored. And Lordship will kindly appreciate that what was the relief given in 2013 to the other writ petitioner, seniority, back wages, and 2 lakhs lump sum, is what has been given to him. This period of 10 years, which he could not prosecute, has not been taken into account by the learned single judge. I have been given the same amount of compensation as 2 lakhs. That 2 lakhs remains the same. Now, the seniority, what if not back wages, it is as compensation.
And the seniority minor.
And the seniority, the other fellow got a 13. And I was acquitted of that matter.
Well, that is not a fault of employer, my lord. Seniority, man, that is his fault, my lord. But initially he was convicted, but subsequently, but rightly or wrongly, he was, that is not the fault of the employer, my lord. That is lump, back wages as a lump sum amount. Well, that is my humble submission. The seniority cannot, he is not entitled for the senior protection of the seniority, my lord. Because this is not for the, that is not the fault of the employer, my lord. So in that period, seniority may not be counted. Yes.
May I just point out one thing, my lord? The appeal is against the relief granted to me. It is not against the finding that that disciplinary proceeding was wrong or something. It is only against the relief that has been granted to me by. And only it is against them. Why I'm interesting is the department has a habit of going up now. If they take up the entire appeal in challenge again, if they're allowed to challenge the entire proceedings as such. But, although he has been reinstated now, they have said the pendency of the writ appeal would not be under orders of this court. In fact, in the review, in the IA, their claim was that we are challenging only the review order, not the writ petition order.
No, both we have.
No,
yes,
the IA may be seen, my lord.
but in writ appeal, we have challenged the both.
Only delay in review is condoned. My lord? No, if lordship will have that is what I was trying to point out. I was absent that day because my name was not shown in the cost list. I would have opposed it on that ground. The IF lordship has, they have only prayed for review, the condonation of delay. The delay was required to be condoned only for the purpose of the review, not the writ petition. So findings in the writ petition were never questioned. What is questioned is only the relief granted in the review that I will be reinstated. That part was questioned. Lordship will find the prayer. That is how 133 days was, 103 days was calculated. It was my review, not their review. Page 7.
Well, notice was served upon them and on that basis for the condone the delay, my lord.
It is only on review. Lordship will find page 5, para 3. Only for review petition. Merger is only to the extent that relief has been changed. Otherwise, everything remains the same. Lordship will find. I filed the review.
Item 22.
My Lordship, I beg to appear virtually, my Lordship, for item 22. My Lordship, may I proceed, my Lordship? My Lordship, may I permitted to make my submission, my Lordship?
Yes, my lord, for respondent number 4. State GST, Lordship. Uh, Yes, Lordship, here, Lordship, against the so-called notice, Lordship, with the amendment made in Finance Act 2024, if he approaches the authority, then if he is satisfied the ingredients of section 16.5, the newly inserted section, Lordship, then they will review the whole proceeding, Lordship. But with regard, that will be made subject to if he is satisfied that. No, Lordship, here with regard to the so-called notice.
I could not hear your voice, my Lordship.
Up to November 21st, 2021, if they have filed, then if they satisfy the other condition in the section 16.5, Lordship, it will be granted. Or Lordship may direct it, the authority will do the necessary step.
My Lordship, may I say something, my Lordship? Lordship, I could not hear, I'm not able to hear what my Lordship, your Lordship. I could hear other, my friend, respondent counsel, my Lordship. My Lordship, no, my Lordship, you are not audible, my Lordship. Apologies, my Lordship, I could not hear. I could hear respondent counsel voice, my Lordship.
Item 24.
Lordship, another fact in this case, they have challenged notification. No, Lordship, the matter is pending before Supreme Court also. Lordship.
Lordship, my small request in this case, my lordship, the main demand is covered by the latest amendment and
Item 24.
My lord. Here, my lord, honorable lordship, Nair may not inclined to take the matter. Yes. Yes. May not be inclined to take the matter. My lord, the entire allegation and entire center point is the Aparajita Patanayak. Problem.
28. 31, 32. Item 28.
Please, your lordship. Your lordship, there is some difficulty today. Kindly adjourn the matter for the day, your lordship.
I may point out one aspect. On the last occasion, this matter was retyped from the green bench on account of urgency. I appear for the private respondent. There's an interim against us. If I may pray for an accommodation, my lords may take it up on a fixed date, perhaps on 21st. But then that by Mr. Dita.
21st.
21st.
Then item 31 and 32.
Lordship, there's an interim order. BPO pleasure.
May it please your lordship, and item 30 and 31 may kindly accommodate me today, Tuesday, your lordship. Obliged.